I often will recommend that victims' families sit down with the prosecutor and say things like, can you kind of talk to me about the types of evidence that's going to be shared in the courtroom? If it's evidence that you can show me now, can you talk to me about that, what that is, and maybe give me the option of seeing it prior to going into the courtroom? But can you at least give me a heads up?
Welcome to the C.O.P.S podcast. I'm your host, Tony Williams, the multimedia manager here at Concerns of Police Survivors. On today's episode, I'm joined by Angie McCown, the Victim Services Director of the Texas Department of Criminal Justice, to talk about preparing for trial. Angie has worked alongside cops for 22 years as a mental health professional at retreats, camps, National Police Week, and more. She's been helping survivors for a very long time, and we're happy to have her here. Welcome, Angie.
Thank you.
Angie, before we get too deep into the trial preparation process, because it can be very big and very ominous to most folks, can we just start with a little roadmap of what that process looks like from preparing to a verdict, what that process roadmap sort of looks like for most survivors?
So once a crime is committed, typically what will happen is the law enforcement agency who is responsible for investigating the crime will start their investigation. That involves many levels, but once they feel they have gathered all of the statements and evidence to support whatever crime has occurred, then they will take that evidence and they will present it to the prosecutor's office. And the prosecutor's office may have been involved from the moment the crime occurred. That's true oftentimes in cases that involve law enforcement officers, or they may just be joining the investigation at the time that the case is presented to them. They will review the case file that the investigators are submitting. They will make a determination as to whether or not to go ahead and accept it as is, or they may send the investigators back out to gather some additional statements or additional footage at the scene, etc. Once they have accepted the case and determined that the charges that are listed are appropriate for the crime, then they will formalize charging the defendant and prepare to take their charges before a grand jury. And a grand jury is made up of your peers. So it is individuals in the community who serve for a period of time on a grand jury. And the purpose of the grand jury is not to find guilt or innocence. The purpose of the grand jury is simply to determine that the facts of the case support the charge that's being given. And so typically those are closed hearings, which means family members cannot be in attendance. The defense attorney, the defendant, and the prosecutor, and any witnesses that they may call, which is usually fairly limited and typically only going to be the law enforcement lead investigator. So they'll present all of their evidence to the grand jury, and then the grand jury will make a decision whether or not to no bill or true bill. If they no bill, their message is that you do not have the evidence to support the charges that you're filing. If they true bill, then they are saying to the prosecution and the law enforcement agency who investigated the case, you do have the evidence to move forward with these charges. And that's called an indictment. And at the moment of indictment, all of the pre-trial preparation begins. And that can include a multitude of pre-trial hearings for a whole multitude of reasons. And hopefully that eventually lands in a situation where a trial date is set. And the defense and the prosecutor will get together to select a jury during voir dire. And once that jury is selected, then the actual date will move forward and you'll have a hearing. Hearings can last a matter of days, and they can also run weeks and sometimes into over a month. During the hearing, a whole variety of information and evidence is presented till both sides rest their case, at which point the judge gives instructions to the jury about how to deliberate. The jury is then sequestered to deliberate. And that also, as you probably know, can take a few hours or weeks. Once the jury has a decision, they come back into the court. The foreman presents that to the judge. The judge asks the jury to read their decision, and that's where we get either a guilty or a not guilty verdict, or you have a hung jury. In a guilty verdict, then the judge will set a sentencing hearing. So that sentencing does not happen the same day that the judge finds the defendant guilty. The sentencing hearing could be in a week, it could be in 4 weeks. And at the sentencing hearing is where the victim's family will have an opportunity to stand up and give what most people refer to as a victim impact statement orally. It's actually called allocution. A whole variety of other things will happen during the sentencing hearing. And then depending upon the decision that the judge makes, the sentence will be handed down. And at that point, the defendant will know what their sentence is, whether or not they've been sentenced to probation or incarceration, and for how long. And that will end basically the trial process. And then the next step will be post-conviction.
So it seems like it's a very lengthy process at times. With that, we know that there are many survivors facing a trial in the near future who may be nervous, scared, angry, overwhelmed, just a multitude of things. How does one even start sort of preparing for trial?
So, it depends on where they're at in the process. I always suggest to people that the moment that law enforcement indicates that they've handed the case over to the prosecutor, that's a good time to reach out to the prosecutor and potentially request a meeting to discuss victims' rights, who in the family will be notified about pretrial hearings and about trial, how to get those notifications, and just a general understanding of what the charges are and what the punishment parameters are. A lot of individuals will make assumptions about if somebody's being charged for negligent homicide or for murder. They'll make assumptions about what kind of sentence that entails. And until you actually talk to the prosecutor so that they can explain all of that to you, there's a good chance you would have erroneous information. So I think, as soon as is possible, you want to meet with the prosecutor and just kind of introduce yourself, find out how to get information about what's going on in the trial process, and then also make sure that they understand that it's your intention to be able to participate in as much of this as possible. And that's sort of what kicks off your preparation. Each state has crime victims' rights, and those rights are typically extended to the immediate next of kin. And then some rights also are inclusive of family members. Typically, that's going to be a spouse, children, parents, and siblings. But each state is different, so it would be important for you to make sure and Google your state's crime victims' rights. You know specifically what you do and do not have access to. If you are not considered one of those victims who has rights, you are still able to ask the prosecutor's office to notify you about what's going on in the case so that you'll be prepared and able to attend the trial if you choose to. Some prosecutors will put that responsibility on the immediate next of kin, and that creates a burden for that person. So it's, I think, much better when you're all able to kind of register with the prosecutor's office so you're each getting information, and that way there's no gaps in understanding where the trial process is. As it gets closer to the trial date, you'll want to make sure that you've had the opportunity to complete a written victim impact statement. And that should be made available to you by the prosecutor's office, but you should also be able to Google your state. So, for example, Arizona victim impact statement. And that form should pop up and you should be able to complete it online or print it out so that you have it. That is a document that the judge will utilize when the judge is determining sentencing. So you want to make sure that you've completed that well in advance. And I also recommend to people that they go ahead and start making some general notes about what they would want to be able to say orally in court for a victim impact statement in the event that they have the opportunity to do that.
If I remember correctly, that victim impact statement also helps you be a part of the process later down the line.
Right. The victim impact statement is utilized by a number of criminal justice professionals throughout the process. It starts with prosecution. The prosecutor is going to look at that victim impact statement. They may utilize the victim impact statement to determine whether or not to set a restitution amount that will be required for the defendant to pay. They may also be looking at a variety of other factors that are in that victim impact statement just to really be able to convey to the court the impact that the crime has had on the family. As I said, the judge reviews it and considers it both for sentencing, but also in the event that there's a plea agreement, they will consider it prior to that plea agreement. And then once the defendant is either sentenced to probation or to serve time in prison, that victim impact statement will be transferred either to the probation office that will be supervising the defendant or to the prison victim assistance folks who oversee providing services to victims post-conviction. Most victim impact statements will have a few questions in there, such as if the offender is sentenced to probation, do you want the probation officer to be in contact with you? Yes or no? If the defendant is sentenced to serve time in prison, do you want the corrections agency to provide notifications to you? Yes or no? If the defendant receives a sentence that makes him or her eligible for parole, do you want to be notified and able to potentially protest parole? All of those things are kind of listed in the victim impact statement, and that's really your key to continue to be notified and to have the option to be involved in the case as it moves all the way through either the death of the offender or the offender flat discharging his or her sentence, which basically means he is free and clear from the criminal justice system at that point. So that victim impact statement keeps you informed and involved throughout the process.
And that's something you would need to have prepared before you go into the courtroom.
That is something that you can complete just as soon as the grand jury indicts the case. And it typically is a form that asks those questions. It collects your contact information so that it would know how to notify you. It also asks some brief questions that you answer about the physical, emotional, and cognitive impact that the crime has had on you. So it collects some general information that is typically determined in each state by statute. And then that information is preserved and shared with those criminal justice professionals who are required to take that victim impact statement into consideration when they are making decisions or when they are sending out notifications about a change in status in the criminal justice process involving that defendant.
When trial starts, we've talked about this just a little bit, but can we go over what's actually going to happen in the courtroom?
So what's going to happen in the courtroom is that, it depends. with a lot of these cases, unfortunately, they are determined to be what we would consider in a community a high profile case. And as we all know, law enforcement in general gets a lot of heat oftentimes. And so the first thing to be aware of is that you may have a case where a number of people show up just to sort of gawk and be present in the courtroom. And I hate to put it that way, but that is the absolute truth. So the first thing that has to be determined is how many of you and your family members are attempting to be present during trial. And whether that's 5 of you or that's 25 of you, you need to have a conversation with the prosecutor about what's available to you in the courtroom. Are they able to reserve a row or 2? Are they only able to reserve 5 seats? In which case, you need to be aware of that. And if you're anticipating that a lot of people are going to show up and try to get in to watch this trial, you're going to need some of your family members to get there early, unfortunately, and stand in line. So these are conversations you want to have prior to the start of trial. You need to prepare yourself once you get into the courtroom. Although it's obvious that you would not be going to trial unless the defendant was pleading not guilty, because if the defendant pleads guilty, then you don't have trial. You simply have a plea agreement. But people don't really, they don't really anticipate the impact that it's going to have on them being in the courtroom, looking at the person who murdered their loved one, and that person being asked to stand by the judge, and the judge asking, been charged with blah, blah, blah against blah, blah, blah. How do you plead? And the defendant says not guilty. That usually creates quite a intense reaction for most victims of violent crime. And so you just need to kind of prepare yourself for how you're going to stay calm when the defendant says that, or quite frankly, when anything else comes up in the courtroom. It is the judge's responsibility to maintain decorum, maintain a courtroom that is filled with respect and dignity. And so any loud outbursts in a courtroom, even though you sometimes see this on TV, typically a loud outburst in a courtroom is going to require the judge to ask you to be removed from the courtroom, and you typically will not be allowed back into the courtroom until the next break. And so if you want to be able to maintain staying in that room throughout the trial, you're going to have to figure out ways to sort of keep each other somewhat calm throughout the trial. And it starts with that defendant standing up and saying, hey, I'm not guilty.
We've had many survivors talk about learning information through the process of trial that they did not know about the way their officer died or was killed. How does one prepare themselves for one dealing with that upbringing of emotion at the claim of not guilty, but also with possibly getting information or pictures or videos of their officer that could be traumatizing?
Sure. So as you can imagine, when law enforcement is investigating any case, and that would include the death of a fellow law enforcement officer, there are certain pieces of information, evidence, statements that cannot be released to the public in order to protect the integrity of the case and chain of custody of the evidence. And so there are some things that can be shared with you, and there are others that just cannot. And it's not because they don't trust you or they're trying to keep information about your loved one's case from you. It is because they're trying to do everything possible to ensure that when they go to trial, their case is sound and solid, and that there's nothing that could create a mistrial or an appeal. So So you're likely to go into the courtroom not knowing everything that's going to be discussed. I often will recommend that victims' families sit down with the prosecutor and say things like, can you kind of talk to me about the types of evidence that's going to be shared in the courtroom? If it's evidence that you can show me now, can you talk to me about that, what that is, and maybe give me the option of seeing it prior to going into the courtroom? But can you at least give me a heads up? So examples, as hard as these are to hear, would be, are they going to play the radio call? A lot of officers wear radio mics on their uniforms and vests. And if someone's been shot and they key their mic up, not only are you going to hear their voice, but you may hear some other sounds that are associated with having just been shot. So is that going to be played? Are they going to show autopsy photos? Are they going to show crime scene photos? Is there video cam of my officer? All of those kinds of things, so that you can kind of prepare in your head, is that something that I feel like I can stay in the courtroom for? There are some prosecutors that will tell victims, even if we could show you the evidence in advance, we're not going to, because we want the jury to see your reaction when you see it for the first time. I don't agree with that. If the prosecutor is relying on your reaction in the courtroom, that's concerning to me. Prosecutors should be better prepared, and that should not be a requirement. So I think you have to do what's in your own best interest. If you know that when they play that radio call, or when they show those autopsy photos, that that's something that you're just not in a place to witness during trial, then I think it's perfectly okay for you to say, hey, when that evidence is about to be shown, I want the victim witness coordinator, who works directly for the prosecutor, who will be responsible for attending to your needs during trial. I want that person to come tap me on the shoulder and lead me out of the courtroom so that I don't have to see or hear that, and then let me know when I can come back in. I personally think the jury notices that as well, and that's just as powerful as seeing you react. The other problem is if you have, again, an loud outburst as a result of evidence that's being shown, they're going to escort you out anyway. So I think you have to prepare yourself for things like that. I also think that it's okay, excuse me, if they're showing something and you've made the decision to remain in the courtroom, it doesn't mean they have to look up at the screen. You can look down. You can close your eyes. You can do a variety of things to keep from having to see that traumatic evidence. But I will tell you that in most trials, there is a lot of traumatic evidence that's presented. And that's hard, very hard for anybody to see. And so those are things that you need to think about and consider. The other thing that's going to be extremely difficult for you, potentially in a hearing, is that questions will be asked depending on the nature of the incident. So, for example, if there was an altercation between the officer and the defendant kills the officer, the defense attorney is likely to try and make the officer out to be a hothead, make the officer out to have been the aggressor. That's going to be really hard to hear when you know that's not the case. And so there's just a variety of techniques that defense attorneys use. They're going to make the defendant out to be an upstanding citizen, and you likely will know whether or not that's true. And clearly it's not if he killed a police officer. But those are all things I think that you have to sort of think about and know how you're going to control your reactions in that courtroom when that happens.
Going back a little bit to your voice in the process, I know you hit on allocution just a little bit, which, correct me if I'm wrong, but is your chance to stand up and actually say something for the process. Can we talk a little bit more about allocution?
Sure. So as we said earlier, the victim impact statement is a written document. It's a form that you complete, but oftentimes that term victim impact statement and allocution get intermixed. And so allocution is actually the legal term for you having the ability to stand up in the courtroom and address the defendant in the court about the impact that the crime has had on you and your family. Each judge is different. Some judges will allow every member of the family to allocute, stand up and speak to the court if they choose to. Other judges will say one person and one person only, which is why it's also great to, in addition to your written victim impact statement, to put whatever you were going to say in allocution in a written document and ask to have that presented to the judge so that it can be included in the defendant's file and available for review for other criminal justice professionals who are making decisions about the status of the offender. So typically what's going to happen is after the defendant has been found guilty and they set a sentencing hearing, it is during that sentencing hearing that you actually will allocute. So that's when you're allowed to stand up and give those oral victim impact statements. You want to talk to the prosecutor to find out how that's going to go, who's going to be allowed to do that, how many of you are going to be allowed to do that. If the family is collaborating with one another and getting along, if only one or two people can read, then maybe you can combine some of the points in your individual victim impact statements. And then depending on the state you're in, some states allow you to read your oral victim impact statement or allocute prior to sentencing, and it's taken into consideration in terms of how the judge is going to sentence the defendant. Many states, such as Texas, do not allow you to allocute until after the defendant has been sentenced. And in fact, the court reporter does not even take a transcript of that, which is why it's important to have a written version of it to submit to the court. And that's a whole separate podcast that we're not going to go into, but know that that is the case. I always recommend that people do not get up there and try to do this off the cuff. It's very unnerving to allocute in front of the defendant in a courtroom full of people. I always recommend that you have it written down, sort of a script. I recommend that you've read that out loud to yourself and to other people prior to coming to court, because it's one thing to write it down. It's another to open your mouth and have to say it out loud. I also recommend that you ask the prosecutor to request permission from the judge to have a backup who can read your statement, your allocution, in the event that you get too choked up to do so yourself. And those are all things that you should plan out in advance. But I recommend that people start taking notes, as I said earlier in the podcast, very early on after the crime has occurred, so that when it comes time to actually put that oral statement together for allocution, you've kind of got some notes or bullet points that you can pull from. The other thing that I will say to you about allocution is that you'll oftentimes see in movies and on TV, somebody gets up on the stand and they cuss out the defendant. Well, that's not true in the real world. As I said earlier, judges are required to maintain respect and dignity, that sort of decorum in the courtroom. And they're probably going to stop you if you start cursing at anybody in the courtroom. The other thing to keep in mind is that, if a defendant were the kind of person who would respond to that kind of chastising, who actually has the capability to show remorse, they probably wouldn't have committed the crime in the first place. So it's a little bit of a waste of your voice, in my opinion. I think what works better is to really speak to everybody in that courtroom, to the judge, to the jury, to any people that are in the audience, to the prosecutor, to the defendant, and yes, to the defense attorney, so that everybody in the courtroom has a really good understanding of how this crime has changed your life how it has impacted your life. That's probably the better way to look at how you compose your victim impact statement and how you read it. Don't give that defendant 100% of your attention when you're reading that. That defendant doesn't deserve it. And that defendant probably is incapable, particularly at that moment in time, unless it's a particular kind of crime, they're probably incapable of expressing any remorse anyway.
We get through the trial and we get to sentencing. The defendant is found guilty. What are the next steps from there for the family?
So remember that the steps are the defendant is found guilty, then you have a sentencing hearing. And it's not until the judge has issued the sentence that we're really finished with trial. So very important throughout that entire process that you avoid talking to the media unless the prosecutor has instructed you to do so. You're not an attorney, and even if you are, you're not the attorney prosecuting this case. And the chance that you might say or do something in a media interview that could create a mistrial or an appeal down the road, that possibility is always out there. And so irregardless of how you feel about what's going on, I would hold all media interviews until after sentencing. What's going to happen at sentencing, a lot of people think that that they march the defendant out of the courtroom and put him on a bus and transport him or her straight to prison. And that is not the case. There's a lot of processing that has to occur, paperwork that has to be done. So that defendant could potentially still sit in county jail anywhere from 30 days to several months before he's actually transferred over to the prison system. I would encourage you to register with VINE in your county. That's Victim Information Notification Every Day. And VINE will send you a text notification or an email notification when that defendant is finally released from county jail and transferred to a prison unit. Once he's transferred or she's transferred to a prison unit, even though you've completed your victim impact statement, which should follow him to that corrections agency, I recommend that you reach out to your state's Department of Correction, your state's Department of Criminal Justice, and ask to speak to their Victim Services Division and make sure that you get registered with them so that you then can begin to receive notifications about the status of the offender. And those notifications include things like if he escapes, you're going to get notified. If he dies while incarcerated, you're going to get notified. If he is being bench warranted out to a hearing in the county for a different offense or an appeal hearing, you're going to know he's been transferred from that prison unit back out to the county and know when he's transferred back to prison. If he's eligible for parole, you're going to be notified about that eligibility and have the opportunity to protest that parole. And if he receives the death penalty, that notification will also come to you when and if an execution is scheduled so that you can make a determination about whether or not you want to attend or participate in that in any way. So those are all things that you want to make sure that you've set up with the Department of Corrections Victim Services. What's typically going to happen to the defendant is that he will leave county jail once all of the paperwork is in order, and he will be transferred by bus in shackles to the prison unit. And in most states, there are some receiving units. So he'll go to a receiving unit potentially first, and at that unit, they'll do all kinds of testing. They'll determine whether or not he has any medical needs that the corrections system needs to address. They'll determine if there's any mental health issues, if he needs to be at a particular unit that's more equipped to deal with those issues. They'll determine if he has any work skills so that once he's spent some time in the prison system, they can transfer him to a unit that maybe has that industry at that unit. So there's a variety of things that they're looking at when they first receive him at that receiving unit before they determine what unit he's actually going to be placed in. And you can be following up with the victim assistance folks with the Department of Corrections to find out where is he now, when's he going to transfer, those types of things. Anything that is public record, they should be willing to share with you.
We're running short on time here for the podcast. So just real quick, there's been a lot that we've covered here today. If there's just one thing that you want survivors to sort of take away from this conversation, what would that one thing be?
Well, I can't do one. I'm going to do two, but I'll do them really quick. The first one is to remember once the defendant or offender is transferred to prison, make sure you talk to somebody at the prison system so that they can relay to you the exact sentence that he got and when he will be eligible for parole. It is very common for that to be confusing in the courtroom. It's also somewhat common for that information to be relayed to the family not exactly accurately. And so people will think he's not going to be eligible for parole for 25 years when in fact he may be eligible for parole in 7. So that's the first thing I would say, is just check about the sentence and parole eligibility. The last thing I would say is that, the criminal justice system does the very best that it can to provide justice to families who've experienced violent crime. However, it cannot remedy or take away the harm that's been caused by the defendant's actions. And I think having some awareness of that as you go through the process is really important, because sometimes what happens once sentencing is over and the defendant is sent off to prison, you're anticipating that you're going to feel relieved or some, not joy or happiness, because nobody feels that, but that you're just going to say, yay, he got what he deserved. It's pretty rare that anybody feels that way. And so I think it's really important to prepare yourself for a little bit of a letdown after trial, and to be able, if you've had support, whether it's through a therapist or a C.O.P.S chapter member or a spiritual advisor or a friend, to make sure that you reach out to them after that defendant's been sentenced, because you're likely going to be struggling a little bit. And you may very well have put all of your grief on hold just to focus on trial. And so you might find a flood of grief occurs at that point in time. So just be mindful of that, and be mindful that that might be going on with your other loved ones, and just find the support that you need, and then reach out to support those family members that may be really struggling once the trial process ends.
Thank you so much, Angie, for joining us and coming to talk with us about trial preparation. I know that there are many folks that have found this useful. Angie McCown is the Victim Services Director of the Texas Department of Criminal Justice and has worked with survivors for more than 22 years. And so she has invaluable experience. Thank you for listening to this episode of the C.O.P.S podcast. We'll be back next month.